Good evening. This is John Milburn for Laws 13010 Evidence and Proof. This is week 4 of Term 3, 2018. Thank you so much for those that have joined the live session. Those that are watching as a recorded session, please consider joining your colleagues in the live session on a Thursday evening, 7 o'clock on a Queensland time. Not next week. Next week is the holiday, but commencing 2 weeks from this evening. Now, assessment number 2, the experiential assignment. Probably not what you want to talk about tonight. You probably want to talk about the first assessment. We'll get to that. But I'm going to share the screen, remind you as to the content of the second assessment. You should see that on your screen. It's released at the commencement of term. So no excuses for late submission of work. You've known about it already for 4 weeks. Due on the 24th of January, and I suppose I should probably put in the date, the year there. We'll assume it's 2019 for the purpose of the assessment. And late submission, 5% deduction, usual rules apply. Cut off 9 days after the due date, which in this instance will be Saturday the 2nd of February. So we know what the assessment is, and the task requires you to watch a movie. You can watch both and make a selection after you've watched them. The reason I'm mentioning this again is that it seems to me that with the holiday next week and a break coming up over Christmas, it would be an excellent opportunity to get in at an early stage, secure a copy and watch the movie. You might want to watch the movie a few times. As you're watching the movie, make notes. Understand what the question that I'm asking you relates to and have something in response to it. The reason I think it's important you do this, firstly, is you may have an opportunity. And secondly, as you're reading your material, I would like you to have some greater focus than simply reading it in a passive manner. In the spirit of reading in an active manner, I want you to understand the questions that are asked of you in this second assignment so that as you're reading a case, a piece of legislation, a part of a commentary from your textbook, it might then twig that something relates to that assignment. So you might hear a piece of dialogue or an objection that might be raised or something in the movie that you've selected. And as you're reading, you'll think, okay, I remember that now, and you'll be able to refer it back. What I don't want you to do is watch this movie the night before it's due. That's going to be very hard work. So understand the question now. Understand what you have to answer. Have that right in front of you whenever you pick up an evidence textbook, legislation or case, so that if you see something, you can slot it in. And when you come to write the assessment, you should have a lot of material there already. I hope that makes sense. Any questions about my philosophy there and the second assessment piece? The whole idea is that you look at what you need to achieve and work backwards from that. Those that have worked with me in the past, you know that's something that I emphasize every unit. All good? All right. Let's press on and talk about the first assessment. First, let me share the screen. And this is what I think is the current groupings at the moment. Now, that is if I can find where it is on my... You should see a document, a table of group members and timetable. Is that what you see on your screen? All right. Please, if you can read the print, hopefully it's not too small, read the print, find your name. You should be prosecution, defence, or solo, or not allocated. And if there are changes required, please let me know with an email. But if it affects someone else, then please make sure you CC them in. All right, so if there's any changes required, let me know. The reason I'm stressing this now is soon I'll release some session dates. And you can understand that I don't really want to be involved in a whole lot of, oh, now I've changed groups and this date suits me, but it doesn't suit my partner, all that sort of stuff. So let's see if we can get as well organised as possible before I release the dates for sessions. I know that some people have said, we'd really like this date. Can we work towards it? I will try to accommodate that as much as possible, but I'll provide blanket dates for availability. I have a suspicion that I have a commitment on the day or the day before the assessment is due. I do apologise for that, but there'll be plenty of dates to choose from, including weekends and after hours. All right, so for tonight's session, I want you to bear in mind whether you're intending to be prosecution or defence for the purpose of the first assessment. I'll stop the share now. Next week, we're going to do a dry run as a group, and this might take 20 minutes or 30 minutes. Tonight, we'll just do a 5-minute intro to get a feel for what I've got in mind the next time we meet. So bear in mind that when you do your assessment, it's individual, even though you're pairing up. The pairing up is just so you've got someone you can bounce ideas upon, someone that you can talk to about it. Having said that, you can talk to whoever you like, especially people within the class, with the unit. So it's more a convenience and a collaborative thing, but you're on your own when it comes to the assessment for real. In 2 weeks' time, when we next convene in week 5, what we'll do is I'll provide you with a factual scenario. You'll know whether you're part of prosecution or defence, and I'd encourage you to do some preparation. The preparation might be, okay, if I was the prosecutor or defence counsel in this case, what are the questions that I would ask? And then as a group, you can fire questions at me and I'll play the part of the witness and also the judge, which is kind of similar to what will happen in the real assessment. And there will be a difference. In week 5, which is 2 weeks from tonight, unlike the real assessment, you will have an opportunity to object. And I want you to object. So those of you that are defence, you have a dual task. You must think of questions that will assist in the defence and be prepared to object to questions or answers from prosecution and vice versa. So do you get an idea of what we're looking at here? Okay, let's just do a trial run. I haven't scripted anything. Let's assume that it's the case of Crown against Jill. The factual scenario, you probably guess what it is. Jack and Jill go up the hill. They're trying to fetch some water. Jack falls down, cracks his crown, and Jill then comes down. The cops pick up Jill and say, we're charging you with grievous bodily harm for injuries sustained to Jack in relation to your criminal activity. So those of you that are prosecution, you get to ask me now what questions, just a few questions. And for the purpose of this assessment, for this little exercise, I'll be Jack, I'll be the complainant, the victim. And those of you that are defence, start thinking about what questions you would ask in cross-examination of the complainant victim. And we can do a bit of a dry run of objecting as well. Right, so I'm just going to give you 3 or 4 minutes to think about some questions that you might ask now, and we'll do this for the next 10 minutes or so. So I'll remain silent for a few minutes while you think about it. We right to go? Okay. Don't take this exercise too seriously, just to get a feel for it, to start asking some questions. And while you were preparing, I noted some comments there from Mary. I see Richard is with you, so I've removed Richard's other entry. Sometimes I double up on these things, so I've removed the entry where he's on his own. I hope that's okay. All right, so prosecution. Team prosecution. Let's assume that Jack has now just been sworn on oath. He's in the witness box. The judge turns to you and says, "Yes, Mr. Yes, Madam Prosecutor, your witness." Somebody better ask me a question.
Oh, well, I thought we're doing what we're doing in the assignment. I'm defence in the assignment, so are we going to do that or swap it around?
If you're defence, don't ask me a question. I'm waiting for someone from prosecution to ask me a question.
At what time did the offence?
Sean.
At what time the offence occurred?
The judge says, "Mr. Prosecutor, you should establish the name of the witness, shouldn't you?"
Oh, okay. So provide your name to all the people sitting in the court.
John Brown.
That's all I've got.
Next question.
Mr. Brown, can you outline your occupation?
I'm a concreter.
Mr. Brown, who do you work for?
Myself.
How long have you held that profession?
Okay.
10 years. Now, bear in mind that this is the case of Jill being prosecuted for injury to Jack. So the jury are wondering who this fellow John is that apparently sustained injury.
Mr. Brown, what is your connection to Mrs. Jill?
She's my friend.
Can I jump in as the prosecution?
Yeah, sure.
Could I say, on the date of the offence or the alleged offence, what were you doing and what did you see?
The jury's going, what offence? So what offence are you talking about?
Of Jill committing grievous bodily harm against Jack.
Allegedly. On what day? I'll just stop there. So what I would like to see is this sort of breakdown. What's your name? John Brown. Are you known as any other names? Yeah, people call me Jack. What's your occupation? How long have you been occupied? What's your date of birth? Do you recall the 29th of February 2018? Yes, I do. Where were you on that day? I was in the village. What were you doing? Well, I met up with my friend Jill. And what did you and Jill do anything that day? Yeah, we went up the hill. Do you recall what happened when you went up the hill? Well, we went to pick up some water. Why are we doing that? Blah, blah, blah. Do you get the idea? So as the prosecutor, you've got to draw out the story piece by piece, really methodically, potentially slowly. And even though I'm asking you to write down 20 questions on the assessment, you know that you've got as many as you like, provided we don't go more than 15 minutes. So you've got to be targeted with your questions to get to the point, as it were. Okay, so you get a feel for that. Let's start again. Prosecution, are we ready? The judge says, "Mr. Prosecutor, Madam Prosecutor, your witness." Marcus.
Can you please state your name?
John Brown.
Mr. Brown, are you known by any other names?
People call me Jack.
Okay, Jack, can you please outline your current occupation?
Concreter.
And how long have you been employed as a concreter?
10 years.
Okay, do you recall 29th of November 2018?
29th of November 2018. Do I recall that?
18, correct. Yeah, correction, 2018.
18. Today, yes, I do
Yeah.
recall today.
Yeah. And on this day, what happened on this day? Is anything in particular stand out in your mind?
I went into the village. Boy, justice really does work well in this town. It's the day of the crime, and I'm in the witness box. No, you're right, Marcus. Keep going. You're doing well. I went to the village.
Yeah, who'd you go to the village with?
Sorry? What was that,
Who did you go to the village with?
Oh, I
Sorry,
went on
who
my
did you
own.
go to the village with?
Yeah, I went to the village on my own. All right, thank you, Marcus. We'll let somebody else take over. You did well. One more question, then somebody else can have a go. Yes, Marcus. Last one.
And what village are you? And what village are you referring to?
Smithton. Mary.
So did you meet anyone on that
Yes.
day?
I met my friend Jill.
And then what did you and Jill do?
We went up the hill.
And why did you go up the hill?
Jill wanted to collect some water.
And what happened when you were climbing the hill? Was there anything significant?
No, nothing significant while we were climbing the hill.
So then you went to collect water. Did you actually?
Now, I'll just stop there. I'll just stop there, Mary. Nobody... no, sorry. I'll let you continue. My apologies for interrupting.
All right. Well, one question that was missed was your date of birth.
Yeah, no, that's fine. Don't worry about that.
Don't worry about that. Okay. So
Yep. So we're going up the hill. Nothing significant happened.
So hang on, I've lost my train of thought now.
Yeah, my apologies.
That's okay. So then what happened after you climbed the hill?
We collected the water from the well. That is Jill and I.
Okay. And how did you collect that?
We have a pail on a rope. We drop it down the well, and we then pull it up by hand.
Okay. Did you have individual pails?
No, just the one. We were both pulling on that rope.
Okay. So the containers, the pail that was actually, so the pails, when you filled them with water, were you then individually holding a bucket, or were they like tied together? Like
We were both, there was one bucket tied to the end of the rope, and we both held the rope.
okay. So did you manage to fill your buckets with water that way? With any problems?
We did, yes. We filled 2 buckets and had a container that we took up, and we put the bucket down for the 3rd time, and that's all. That was the last bucket that I remember collecting or trying to collect.
So you had your own individual bucket of water, and Jill had her own individual bucket of water. Is that the case?
No, we took up a container, and we were filling that from the water we collected from the well.
So who carried the bucket in your descent from the hill?
Oh, I don't remember.
So did you help each other to carry that bucket together, or?
Yeah, just be careful. You're starting to lead a little bit, but no, are you talking about
Why don't you remember?
the bucket going up?
No, the bucket's now filled with water.
Yes.
You are starting your descent down the hill. Is that one bucket being carried by both of you, or is it just you, or is it just Jill that's carrying the bucket of water?
I'll just stop there because the witness says, I don't remember anything after the 3rd bucket went down. I don't remember going down the hill. But you did really well there, Mary. That's good. What we might do, thank you very much. We'll just see who else was ready to start. I heard another voice. Was that, sorry? I just couldn't pick up who it was.
Well, why don't you remember? Did something happen?
Oh, sorry, Marcus again. Okay. Yes, something happened.
If no, one else is there,
No, that's fine.
can you tell us what happened?
No, I can't.
Yeah,
No, I don't remember.
Okay, prior to not remembering what happened, did you see anything?
I saw the bucket going down the well for the third time. That's the last thing I remember.
Okay.
How many times would you and Jill make this trip up the hill?
Oh, how many times?
Yeah.
Only once that day, but we've done that many times in the past.
So this was a common occurrence?
What, walking up the hill or
Yeah.
collecting the water or forgetting?
Both.
Both.
The walking up the hill and collecting the water.
Yes, that was quite common.
I'm not a defender, but would we be asking if anybody else was with you to establish that it's only you and Jill?
You could do, yeah, that's right. So you're looking to, as a prosecutor, and I'll just stop there. So you're all doing really well. Remember, as a prosecutor, you're setting the scene and think of it as building blocks so that you're trying to establish one fact after the other and build on it. A big mistake for prosecutors is to presume something which has not already been established in evidence. So bear in mind, this is the very start of a trial. The victim's the first witness. The jury don't know anything about it other than Jill is charged with committing grievous bodily harm on the 29th of February, 2018, or whatever it might be. So that's all they know. I mean, in reality, the prosecutor has an opening and sort of describes and says, look, this is what the witnesses will say. But for our purposes, when you're the prosecutor, you've got to ask a series of generally short, focused questions that build one on top of the other so that at the end of the testimony, we get to see the full picture and we understand the circumstances. So it's a big mistake to jump in towards the end rather than do this building methodical process. Now, the people that were asking questions did really well. Particularly, I gave you no notice about this exercise at all. So a really good job. Do you get the idea of it? Now I don't think anyone objected to any questions. Let's switch it now and we'll go into defense mode. So you've heard the testimony, and let's assume that the testimony was that as the third bucket of water was being drawn from the well, something happened, and Jack just doesn't remember, other than he felt a thud on his head. All right, defence. Judge says, your witness. Travis.
Mr. Brown, thank you for your time. Look, how long have you known Jill?
14 years.
14. And you described her earlier as a friend?
Yes.
And have you had any reason to doubt that friendship over the past 14 years?
Oh, we have our arguments from time to time.
Was there any such argument on the day?
There was a bit of niggle, yes.
Niggle? Anyone else want to go?
Angela.
What was the niggle about?
Well, I saw Jill with some bloke that I didn't think was good enough for her.
Can you describe your relationship with Jill?
Oh, we're friends. We've been really good friends for a long time. She's kind of like my sister.
Kind of like your sister, but you were jealous of her?
No, protective, I would say.
You're protective of her. So this hill that you've walked up, whose land is that?
Council land.
Council land. And who constructed the well?
Oh, I don't know. It's been there for about 100 years as far as I'm
100
aware.
years. So can you explain how the pulley system works with the bucket again? Sorry.
Yes, one rope, one bucket, and you let the rope out into the well. When you can feel there's water in the bucket, pull it up. In this instance, as we normally do, both Jill and I were pulling on the rope together and we brought the bucket up.
Okay, so how were you positioned to both be doing this at the same time? Were you standing above Jill or beside Jill? Or?
Yeah, I was closer to the well and Jill was behind me.
Oh, righto. So I know what I want to say and I know what I think happened, but I don't know how to ask the question. So next person.
That's the hard part. All right, who else is there? Who else is for defence?
I'll give it a go.
Yes, Simon.
What injuries were sustained?
I got a crack to my skull.
What did the what did the doctor say for that? How? Yeah, a crack to the skull.
No objections to that question.
I'd assume that you would have a scan.
I did have a scan.
Speculative.
Sorry, the objection was
Speculative.
speculative. Other objections?
Speculating the injury.
Hearsay, said Sarah.
Could
Yep.
you also say it was a repeat of previous evidence?
Sorry, Sean?
Could you say it was a repeat of previous evidence? Probably not.
No, you wouldn't object on that basis. Sorry, Simon, you were doing really well, and then I stopped your train of thought. So, but you were asking about whether I had a scan. Yes, I had a brain scan undertaken.
CT or whatever, yeah, and it's been admitted. And you were in front of Jill. That's correct.
At what time?
When the rope was being pulled up. When the tail was being pulled up.
The first time, the second time, or the third time?
The third time, before the time just prior to the injury being occurred.
Yes, immediately preceding that, I was standing in front of Jill, closer to the well. She was behind me.
Yep. Did you have? Can you recall if you were holding the rope the whole time?
As far as I can recall, yes, I was. I had both hands on the rope.
Both hands on the rope, and never let go of the rope.
I didn't let go of the rope.
Are you sure of this?
I may have let go of the rope after I sustained a knock to my head. I probably did.
So can you confirm then? That would be too leading, so I won't go down that track.
Well, you can lead in cross-examination. You can lead away as much as you like.
I got told I got in trouble by a judge for leading too much, a magistrate.
In cross-examination?
In cross-examination.
No, you can lead in cross-examination.
No, in cross-examination, I got in trouble.
Oh, okay.
Not in evidence in chief, but in cross-examination.
In cross. Oh, okay. All right.
Really, I gave them the answer, but yeah.
You've always got to know your judge and your magistrate and work in their court. They rule. So, all right. Now, Simon, we'll just see who else wants to have a go. But no, you did really well there. Any other defence counsel?
I'll have a go.
Yes, Michael. Thank you.
Jack, can you just explain to me the construction of the apparatus of the well?
There is a winch, but we didn't use it. We just bypass the winch and we pull the bucket up manually.
Do you agree that it's constructed of very old timber?
Oh yes, the structure above is very old. Yes.
I recalled your evidence earlier that you said that the well was at least 100-year-old.
Yes.
Do you agree that the injury that you sustained to your head occurred as you were bending over the well?
Yes, it did.
Do you agree that when you came to, the injury to your head consisted of a blunt trauma?
Oh, I don't know. You might have to ask the medicos that, but yeah, it was certainly a blow to the back of my head. It wasn't sharp. Yeah. Objection, says Mary. Won't be a sec, Michael. Objection, Mary. Yep.
Not qualified to answer. I mean, you'd lost your memory that day, you know.
No, I'll allow the question.
Allow
the question. Yep. But good objection. Good on you. Coming
You can't
in.
object to that because if you lost your memory, then everything else you've just said prior to that you held the rope at the time.
Well, you remember things up to the moment where you don't. And I remember being struck, and it was a blunt type force. It wasn't a sharp. It wasn't like a sharp injury or that I felt, impact that I felt. Yes, Michael, you're doing well. Keep going.
Jack, I've got a number of photographs that I'd like to show you.
Yes.
And they're here.
Yes.
just as leading into it, these photos are taken of the well in question. I'll get you to respond. Before the incident, and there are photos of the well after the incident. So I'll produce them to you and ask you, do you agree that they are photos of the well before the incident and after the incident?
I'll have a look at them. Yes, the photographs that you show me is the first bundle, definitely the well before the incident. I can't say for the second bundle because I've never been back to the well since the incident.
Do you agree that the injury that you sustained may be consistent with the well collapsing and striking you on the head?
Well, it was a thud, a dull thud, but I can't say what hit me or who hit me or how I was hit.
You know, my friend, my client, Jill, you've known her for a long
Yes.
time. This is Jill sitting in the dock behind
Yes.
me.
Yep, that's Jill.
Do you agree that Jill is a very slight young girl?
Yes.
Very small?
Yes.
Do you agree that when you were walking up the hill that she was not carrying anything?
That's true.
So all that you walked up the hill with that day was the pail?
Well, yes, that's right. I'll just stop you there, Michael. Very good progress. The jury might be starting to doubt whether Jill actually caused this. And what I liked about that was that you were asking questions that were consistent with the body of evidence, but which might lead a jury to consider the evidence in a way that would be consistent with innocence. So thank you for that. All right. Anyone else wish to ask any questions for defence?
Could you?
Sure.
Oh, wait, sorry. I was just asking a quick question. Could you object the photographs on hearsay?
No. Generally, it's quite common for photographs to be presented.
Cool, thanks.
So, no, good question though. Anyone else? I'm trying to scan to see if Sarah. Yes, Sarah.
Can you tell me at what time the incident occurred, day or night?
It was during the day, approximately 11 a.m.
Okay, what was the weather like? Was it sunny or overcast or rainy?
Oh, it was a bit cloudy, but it wasn't rainy and it wasn't that warm. It wasn't that hot.
Okay, when you were taking the first 2 pails of water out of the well and dumping them into the container, did any water spill?
No, not that I recall.
What about the surface area around the well? Was it rocky? Was it grass?
Oh, it's a combination of some rocks and some grass. And there's always a bit of water around because a lot of people use the well and some people aren't as careful as us. There were some people using the well immediately before we started.
So was the ground around the well particularly damp at that point in time, did you notice?
It was damp, yes.
So would you agree that that might make it slippery?
Yes, I agree with that.
And just how tall was the hill that the well is on? It's a hill, so it's not very tall, correct?
No, it's an elevation of probably 30 metres.
Okay. And the base of the hill was grass, or is it still the combination of rock and grass?
It's grass all the way up the bank, but there's a walkway which is concrete.
Okay. So when you were pulling up the pail, was it particularly heavy when it was full of water?
Very heavy.
Okay. And then was Jill talking to you, or were you not talking while you were doing this? Oh
no, so we don't use the winch, so we do it manually as part of our exercise regime, and we haven't got the energy to be talking while we're pulling that up.
Okay, and so would you say that you could hear Jill panting or being tired if it was a exertion heavy activity?
Probably, yes.
Okay, and so after the second pail, how were you feeling? Were you feeling tired?
Yes, I was.
So it is possible that by the time you were getting the third pail up that you were quite tired, the both of you, and a
Yes.
little bit unsteady on your feet?
Yes, I'd say both those things. I'll just stop you there, Sarah. Again, very good progress, and defence is chipping away here. And that's what you do in defence. You're putting forward various questions, and you're always looking for a hypothesis that might be available to the jury when they consider all the facts, which is consistent with innocence. So some good questions there. Now, Ben, did you want to ask some questions?
Certainly, I like to contribute as well, John. Hi, Mr. Brown. Can you point out or name the offender, please?
Can I point out the offender?
Yes, please.
Sorry, what was that, Simon?
Alleged.
Alleged. Okay, no, that's fair enough. And so, Ben, you're a defence counsel. Well, I know that Jill has been charged with the offence of causing me grievous bodily harm. So that's
Right.
Jill over there. That's her
Right.
there.
Is there any weapon involved, Mr. Brown?
Not that I saw.
Do you think your injury is a commonly as an accident?
Yeah, you might, prosecution would probably object there because the term accident, it's a good question, Ben, you've gone right to the heart, but prosecution would probably object because the term accident has a legal meaning as well as a as well as a common, if you like, meaning.
Thank you.
So maybe not, Ben. You may not be able to get away with that question. But if I was to answer it, well, it might have been an accident. I don't know. I didn't see.
Can I go with it's not grievous bodily harm because you would have not needed medical attention for the fractured skull on a different issue?
Yes. So
well?
yeah, I definitely needed medical attention because it was a fractured skull.
But the fractured skull would have healed naturally.
Oh, so now we're getting into a different issue.
I know that's trivial to this. That's right. But just one thing I had.
But not for this witness.
Yeah. Which way were you pulling the...
Well, I'll just let Ben go for a little bit longer, Simon, then we'll come back to you if that's all right.
Oh,
Sorry, Ben.
okay. Well, that's fine. Mr. Brown, have you see Drew using any weapon to hit your head or skull?
I did
you
not.
Haven't?
No, I did not.
The next question I'm asking is...
Yeah, that just didn't come through, Ben.
How would you thinking? Oh, all right. I have a miss for the question. That's the end of the question. Thank you, John.
Thank you, Ben. Simon, do you have any further questions?
Yeah, I was just confused. But before you said that you were in front of Jill, so you're closest to the well?
Yep.
So you were facing the well?
I was facing the well.
Yeah, okay. Cool. That's fine.
All right, good. Okay, look, we might stop there. That went actually longer than I expected. You're all very good on your feet. Very lively. I can see we've got some agile minds in this group. So next time we'll do this, but I'll give you a bit more preparation. And you feel free, all of you who are prosecutors, feel free to free Jill, says Travis. All of those that are prosecutors, please feel free to have a chat to each other, exchange ideas. You can use the Q&A section or whatever you want. Likewise for defence. And those that want to participate next time, what we might do is we might have a structure. And to keep it lively, what I've got in mind is those that nominate, you just nominate. You don't have to, but if you nominate, you're in the prosecution or defence team, and we'll go round robin. So every person, you'll know your order, 1, 2, 3, 4, whatever, and everyone gets one question. I answer it, you move on. So what it means is that you've got to pick up on what the previous person had asked, and you've got to be listening to the answer, ready to ask the next question. So it's going to be an exercise in agility, mental agility, as well as dealing with issues of of admissible evidence. Now, all of that, to add a bit more pressure, within the context of knowing that your opponents can object in the exercise that we run next time. All right, so defence had more time. Yes, defence had the advantage there because they went second. All right, so to get an idea of what we want to do next time, and next time I said 20 to 30 minutes. I think that's probably wrong based on what we did tonight. It may go a little longer, but I think it'll be useful. All good? So as you're reading cases, as you're reading your commentary, as you're reading the legislation, I want you to be thinking about this actively within the context of, well, how would I use that case? How would I use that approach in my case, which is the case that I'll present to you over the next few days. Any questions about that? All right. Let's go back to where we left off in terms of our overall discussion. We were talking about presumptions, I think, where we left off last time. And you'll need to understand the difference between presumptions of fact, which are really no more than really no more than circumstantial evidence, and presumptions of law. So some presumptions of fact might include possession of recently stolen property or continuance. And if you've studied torts, you'd be aware of the Latin term, the concept res ipsa loquitur. Presumptions of law may be rebuttable or irrebuttable. An example of something that is rebuttable is a lack of criminal capacity of a person aged under 14 years. That's section 29.2 of the Queensland Criminal Code. Or a presumption that a confession was given involuntarily if it followed a threat or an inducement. And that presumption is also found in statute at section 10 of the Criminal Law Amendment Act 1894. Or there is the presumption of sanity, section 26 of the Code. Irrebuttable presumptions of law, I can only really think of one, and that is section 29.1 of the Code, which says a person under the age of 10 years is simply not criminally liable for any act or omission. So you'll never see a 9-year-old prosecuted for a crime because there's an irrebuttable presumption of law that the 9-year-old cannot commit a crime.
What about the Venables? Weren't those kids weren't they about that age?
Which one, sorry?
You know, the English case with the little baby that they took, Darren Venables or someone? Weren't they about 9 or 10?
What was that, Simon?
Pardon?
Sorry, I just missed your response there, Simon.
From the shopping centre from his mum and walked down the railroad tracks and killed him.
Okay. Yeah, sorry, I just couldn't quite follow. I couldn't quite hear the answer there, Simon. But yes, so I guess the different laws may apply here, and I can't answer that one specifically, Angela, but certainly in Queensland, have a look at section 29 or 1 of the Code, and that will be the presumption that applies in Queensland. So to be honest, I don't know what the similar counterpart legislation is interstate or in the UK, but there'll be something similar. Oh, Simon said they were 11 in that case, Angela, apparently. So that would put them into the rebuttable presumption category, the presumption that they lacked capacity because they're under 14, but it's a presumption that can be rebutted by evidence to the effect that they did know what they were doing. All right, so that's presumptions. Judicial notice, I think we probably understand what that means. Judicial notice is that which the court will accept because it's common knowledge, generally known. You don't have to prove it. You don't have to prove that Wednesday follows Tuesday. You don't have to prove that night follows day. We all know that. So there are some things about common knowledge, and it may be that the judge in question is happy to accept something by way of what we call judicial notice after an inquiry or without an inquiry. So the judge will say, you don't have to prove to me or bring any evidence to say that Wednesday follows Tuesday. I know that. We all know that. It's common knowledge. It's not something that you have to prove. I'm giving, if it was ever challenged, I'm accepting that Wednesday follows Tuesday by giving judicial notice to that fact. However, the temperature of someone's body, a healthy person, human being, may be something that the judge will be happy to accept, but following some inquiry. It's so notorious, but you might need to know the exact number. So that's something that we talk about in the context of judicial notice following inquiry. So have a look at the statute sections. The Commonwealth level, have a look at section 144 of the Commonwealth Evidence Act. Some things are provide for judicial notice under statute. In the Queensland Evidence Act, have a look at section 65 that deals with maps and charts, territorial limits, and it allows the court to admit into evidence a book or a map or a chart that appears to be a reliable source of information in relation to the question. So these are ways that you can have matters of fact established without having to bring evidence to bear on that point. Another way of doing so is by the process of admissions, both in civil law and criminal cases. So in civil actions, one party can serve upon the other a notice to admit a fact, and the other party can accept that or not. If the other party accepts this fact, then you don't have to prove it, you just rely upon the acceptance of the notice to admit. So, for example, in a motor vehicle accident, you might put on, in a civil case, you might issue a notice to say, notice to admit that X is the owner of this car and Y is the owner of that car. Yet we accept that, tender that. You don't need to bring any evidence. The court will accept it because the parties have accepted it. Likewise, in criminal trials, it's very common actually for defence to admit certain things. So, for example, if you're dealing with an indecent dealing case of a child, then there may be an admission that the accused was born on this day and therefore is this age, and that the victim at the relevant time, the victim was born on this day, meaning that at the relevant time the victim was, 12 or whatever years of age. In other words, you don't have to. The defence is saying we don't need for prosecution to produce birth certificates and things of that nature in order to prove these basic things. Defence have already conceded that. So let's get on with the real argument, is the rationale. So does that all make sense when we're talking about presumptions and admissions? Now, the next concept is estoppel. Estoppel, you'll see estoppel raised regularly throughout your studies. In the context of evidence law, you may have cause of action estoppel, or you may have issue estoppel. And in general terms, a cause of action estoppel, res judicata, arises where the action has already been agitated through a court process, and therefore the party seeking to agitate it again may not raise it. And the defence is, we've already dealt with this, we're not going to deal with it again, it's stopped. Mary, do you have a question or comment?
No.
Oh, okay. Yep.
I thought you were going to go into the question that you asked last week about Ocean.
Yes, I will be soon. Are you ready to go with that answer? It'll be.
Oh, yes.
It's coming up in one moment. So in criminal cases, we have res judicata. It's in the code. Have a look at section 16 of the criminal code. A few cases that relate to that. And you can have issue estoppel in criminal cases where you have situations where certain issues are established beyond others. Now, estoppel in civil cases, we have the argument in relation to issue estoppel and shun estoppel. Now, Mary, do you want to tell us about and shun estoppel? on mute there.
Sorry, I'm not that quick as everyone else at unmuting. Or Anshan. How do you pronounce it? Anshan? Anshan? Anshan.
I call it Anshan, but I haven't heard anything to the contrary. But
it originated from the Port of Melbourne Authority versus Anshan. It was a High Court matter, and that's where they laid down the principle for it, and it got its name. But what it really is the test was laid down about reasonableness, and what it really means is that if you have already brought a matter and you failed to, mention certain aspects of that, and then you try and bring a claim for that later, then that can be estoppel. And the original case was to do with, a person who suffered some damage as a dock worker. He was injured by a crane, and so he sued the authority in Anshan, and then they let that case go, and then they came back after he was already awarded damages and that case was finalised. They came back with a condition from the crane company saying, part of it was that it was his own responsibility. There was a contingent in the actual contract, and they said, no, that's where it kind of originated from. So basically what it is the risk of waiting, like in your original case, it's a cause of action where in the original case, if you don't bring, everything to the attention in that first case that's applicable to it, and the same parties then end up where another action is brought and it wasn't mentioned in the first case, well then it's Anshan estoppel.
Very good, Mary. That's excellent. So the lesson to be learned, and thank you for that, is that when you're agitating a case, when you're completing the pleadings, you need to be comprehensive. And it's no argument generally to say, well, look, I sued you unsuccessfully under contract, but I could have just as easily have sued you under consumer law. So I'm going to bring an action now against you on consumer law, and we'll see how that goes. You would say, look, Anshan estoppel precludes you from being able to do that. You ought to have raised the issue of consumer law in the same case, in the same pleading, as you raised a breach of contract. I hope that makes sense. So thank you for that. Issue estoppel then also applies in civil cases. Have a look at Blair against Curran in that regard. And when it comes to convictions, there are certain presumptions that apply. I'll simply refer you to the Queensland Evidence Act, sections 79, 80 and 81 that deal with issues about convictions as evidence in civil proceedings and the issue relating to rebuttable presumptions of law, particularly in relation to things like defamation. Have a look at some commentary in your text about subsequent criminal proceedings, and that is probably all I need you to do for this evening. Time has got away from us, but I think it was useful going through that exercise because I really wanted you to start thinking carefully about how you deal with these real issues in your assessment. All right, so we're behind in our reading in terms of what we're dealing with in class compared to the reading. So you should be getting well ahead of what we're discussing now. You should be on top of some of the basics by now. So I take it you all know the three basic types of evidence: oral, documentary, real. You should all understand direct versus circumstantial evidence, and you should all understand primary versus secondary. Make sure that you're aware of the provisions in both Evidence Acts, Queensland and the Uniform Evidence Act. Make sure that you're aware of relevant cases. It's a good idea to have this chart where you identify at least maybe one section with one case. Don't forget, sometimes the things like the Uniform Civil Procedure Rules may have come to bear on these issues also. think about how to prove documents and look at, in the Commonwealth sphere, sections 48 and 51 in terms of documentary evidence. I'll get you to do that as private research. Likewise, in the Commonwealth Evidence Act, have a look at section 53 that deals with the issue of views. And in the Queensland legislation, as I've mentioned before, you have this overriding discretion in section 130 of the Evidence Act that you can rely upon. But if you use that as an objection, I object, should be excluded because of section 130. Bear in mind the judge is likely to follow up with a question. You need to be more specific than that. So make sure that you have some follow-up matters to argue. For example, in the case of R against Ray, 2006 QCA 207, that Ray is RAE, the Queensland Court of Appeal said it was unexceptional and proper exercise of discretion for a trial judge in a murder trial to allow the jury to retire with photographs, even though there were pretty ghastly injuries depicted. All right. What we'll do next week is in 2 weeks' time, week 5, we'll do our exercise. Please prepare for that, and it'll be more structured than what we did as a trial run tonight. And in terms of your reading, keep reading ahead. Make sure you watch these movies that I mentioned right at the start tonight. And as you're reading the material, you're cross-referencing into these more practical exercises that we're giving to you. Does that all make sense? All good? All right. Any questions before we wrap up for this evening?
I just have a quick one, John. I was reading about authenticating computer evidence, and I found that one of the ways you could get evidence from a computer kicked out was if you proved this was under the Commonwealth Acts. It was, I think, sections 146 and 147, that if you show the computer was malfunctioning at the time the evidence was collected, you could make it inadmissible. Is that true?
It's true. Yes. So these are rebuttable presumptions. The same sort of thing applies in terms of devices used for testing for breath analysis or speed of motor vehicles. The presumption is that what is on the certificate applies, but you can bring evidence to rebut that presumption. I hope that answers your question, Sean.
Yep, it does. Thanks.
Great. Thank you. Any other questions, comments? All good? Okay. Well, enjoy your break next week. So I won't be online next week at this time, but in 2 weeks, I want your thinking caps on and lots of mental agility, please. We'll see who wins between prosecution and defence. All right? We'll see you in 2 weeks. All the best. Bye then.